Hello, welcome to Pro Bono, sponsored by Cahoon Legal. I'm your host, Amber Cahoon, an attorney in North Texas. New podcasts are available monthly, and you can subscribe on most podcast platforms and find us on social media. Follow us at Pro Bono Show. Remember, this podcast is for informational and educational purposes only and should not be considered legal advice. It is not intended to replace professional legal advice. This information is catered towards Texans with a focus on Texas law. Now, what we have coming up for you on today's show is about estate planning. We've talked about it previously on another show, and we were focusing on a couple aspects of it. And now we're going to focus more on ways to avoid probate and then common mistakes to avoid. So a lot of avoiding. And then we'll talk about some movies I've watched lately. So let's get started. So first, we're going to talk about ways to avoid probate. And what you may not know is that, what probate is. And probate is the court proceedings to verify a will and give authority to the executive or the administrator to administer the wishes of the deceased. If you didn't have a will, then it is a process that you go through where the court follows the intestate law to ensure that your assets are going to the proper people. Intestate means that you've died without a will. In Texas, usually we'll have to go through probate unless there's certain things, like it's a small estate. There are ways to avoid it even after a person has died, depending on the size of the estate. So again, it's always important to contact a legal professional. Cahoon Legal can help you with that in both estate planning as well as of probate. But so we want to avoid it if at all possible, because it is and can be a lengthy process. Now, lengthy can mean anywhere from 6 months to a couple years, depending on the size of the estate. And there's a lot of aspects of it that, you have to have a legal professional go through probate with you. You actually have to have an attorney. So there's costs involved that are a burden to the estate and the loved ones. So first of all, we can talk about joint ownership. So joint ownership of property is one of the best ways to avoid probate, because it will pass to the other owner. So this is joint ownership with the right of survivorship. That is very important to make sure. And so what happens is, once one owner passes or dies, then the other owner automatically owns the property outright. No probate is necessary to transfer it. It just becomes some paperwork that we have to file in the deed records to show that one has passed, and that then the sole ownership becomes the other party. That's another thing people make a mistake that's later, but is not following up after someone passes to make sure all the property is done, transferred properly. So there are two forms of joint ownership and to have the right of survivorship. One is joint tenancy, and this usually doesn't have to be with a spouse. This can be that you own property together. Maybe you bought a car with someone else. It could be your parent or your sibling or a child. Or it can be a house, as long as you both are owners. What happens is that when you own that, you both have equal right to that piece of property, whether it's real estate or a vehicle. And it's usually best handled through what's called a joint tenancy agreement. This is best for real estate, especially. And in that agreement, you lay out that each party has equal shares and what is to happen upon the passing of the other. So this is something to consider for those that are not married and are in some sort of other familial relationship, like I said, with a parent or child, something like that. You can have a joint tenancy. So in Texas, we are a community property state, which means that property and income earned while married becomes part of the community property. There's a little more detail about it than that, and that's more for a family lawyer. But ultimately, you can actually sign an agreement to own property as a survivorship of community property. And that also avoids probate when one spouse dies and then the other one becomes the sole owner. Now, these two ways to own property are options that you do have to have an agreement about, but you may not be necessary because there's a lot of ways to own it as a joint owner with right of survivorship. That is very common just in regular deeds, that you have co-ownership. If you're married, that's what happens. You can talk to your bank. So there's different ways that that's already kind of built into systems. Like if you both get a bank account, you just want to make sure, does it have a right of survivorship? And it may not be necessary to do any of this additional paperwork. And following that, bank accounts, they have what are also called payable on death, POD. So they're designations to a bank account or savings account, certificates of deposit, that you control all the money and they don't have any control of it. But upon your death, then it actually will transfer to the beneficiary. Now they have to contact the bank and fill out whatever paperwork they require, but it is not necessary to go through probate to have that happen. That's a safer way to have property. I don't usually advise people to have a joint ownership, especially with non-spouses, of like a bank account. So some people, if they're older, they might decide, oh, I'm going to put my child on my bank account. That could be okay, but there's so many times that the child spends the money that they're not supposed to, or maybe it's not a child, whatever, but there can be problems involved with that. So a better option is actually the payable on death. So you control the money completely, and only after your death does that beneficiary actually get access to the accounts. Similarly, you can do that with securities, your investments. So oftentimes, when you sign up for those type of accounts, they will ask you to designate, a beneficiary that they are paid out to. That's really important that you make sure that all of those type of accounts are set up with the beneficiary listed so that they can pass to the beneficiary without having to go through probate. Another thing, which we actually talked in the last estate planning podcast, was a transfer and death deed for real estate. That's something in Texas that they started in 2015, where you can transfer your property outside of probate to the beneficiaries that you have listed. This is actually also in many other states, but each state has kind of their own type of document that you have to fill out. So it's important to make sure that you have a legal professional help you with that, because it also requires that you have the legal description. And so if you fill it out improperly, it can cause some issues. Another thing that you can do, which is called a ladybird deed. It's not as common now because we do have the transfer and death deed, but it used to be much more common. And so again, there are certain ways that they have to be done. And so it's really important that you call our office or another attorney that handles real estate or estate planning. Another thing people don't realize, but the Department of Motor Vehicles, or DMV with Texas, they have a form that you can fill out, which is a transfer and death registration for your vehicles. And you fill out the form and it does that for your vehicle. So it's actually called the beneficiary designation for a motor vehicle. I think it is form VTR 121, and you can get that with the Texas Department of Motor Vehicles. Last but not least is a living trust. I say this last because it is more costly to get set up than the other things that I listed. You must have an attorney do a trust because it's more complex, and you really need to make sure that you understand how it's going to work and that it's done properly. But you can actually put any type of asset into a trust, and the documents, the trust documents, are created similar to a will. But just creating the trust doesn't put anything into it. So if you have assets that you're transferring, you'll have to find out and work with the estate planning attorney to, and that sometimes is extra, depending on the amount of assets you have, to put the actual assets in the trust. You have to change over deeds. You have to change titles to the actual trust, the name, and how it's set up. It's really specific. So that's something that you definitely need to talk to an attorney about. But once that's done, all the property that's in the trust is now controlled by the trust, and that trust survives you. And so after your death, anything that's in there does not have to pass through probate. So the best way is to make sure just that it all goes into the trust, but during your lifetime. Some things that people don't realize that if they have a will that has into a pour over trust, they actually will still have to get that probated. So it doesn't necessarily avoid probate. You actually have to have the trust created during your lifetime and the assets put into it during your lifetime for you to avoid probate. Okay, so let's move on to some of the common estate planning mistakes that people make. And the first one being that you just don't have an estate plan. You don't have a will. You don't have anything set down in place for you if anything were to happen. And so I know, especially if you're young and you don't have a family, it doesn't seem like maybe you should do that. But if you have any assets in your name, these are things that you can do to make sure that they are going to, who you want them to. So this goes for anyone that does not have a will. If you don't have a will, then it will follow the state's intestate succession. So if you have a spouse, it will go to your spouse. But if you have a spouse that you have children with, so it'll go to your spouse, not your children. If you have spouse and children from a previous relationship, it will actually be a split between your spouse and those children. If you have a spouse and parents, then most of it will go to your spouse and a portion of it may go to your parents. If you have a spouse and siblings but no parents, then similar, you'll go to most of your spouse and then some to your siblings. So these are things that people don't realize, that it's the line usually is spouse, children. If no spouse, no children, then parents, siblings. So that's kind of how it goes out, just the kind of the first rung of intestate. So even if you're young, if you do have some assets, you can definitely have a will, and it doesn't have to be complex at all. But if you have assets, along with the things I've already talked about to avoid probate, it's definitely important to get an estate plan in place, so that even an estate plan is not just a will. There's lots of other documents that are appropriate actually during your life to make sure that your estate and your finances and actually the care of yourself are taken care of, and you're in control of that. You put down who you want to have control and do those things for you when you're unable to do them for yourself. Another thing is that if you have a will and you haven't updated it, so let's say you've lived for many years of your life in another state, you have all your assets there, maybe you have a will there, you move to Texas and you don't have any assets anymore in that state, and you haven't gotten a new will for Texas. In that case, you will actually have to get a new will, a Texas will. But let's say you've already gotten a Texas will years ago, you've gone through divorce, you've bought different houses, you've had more children. There's many different things that would be a reason for you to update your will. But especially if it's been many years, that's another reason. And if you've moved to a new state, you have acquired a lot of different assets, it's important to have a will. Again, if you have assets in other states without a will or a way to avoid probate in that state, you actually will have to usually do probate in each one of the states that you have assets. depending on their rules and their laws and how much that asset is worth. They may have similar type of, ways to avoid it, like Texas does, so that if it's a small amount, you may not have to do it. But again, if you have assets in other states, you really need to reach out to an estate planning attorney in that state to find out what you need to do to protect yourself. Another way to do it is to put it all in trust. Like I said before, that avoids it. Probate. So the second thing is, and people don't like to think about this, is disability, not planning for disability. And disability doesn't necessarily mean that you have a lifelong disability. It could just be your aging and health concerns that change your circumstances. Maybe you have cancer, or you have another issue that has come about with your health, and that you aren't always able to make those decisions for yourself. And so those are things that you need to get in order, so that you're not taken unexpectedly and have something happen and you don't have those in place. Because if you have a disability and you can't make decisions for yourself at any point, and it is not a temporary, like you've been under sedation, you can't make a decision, but once the drugs are clear, then you can. If you are disabled, you can no longer actually execute those documents for yourself. Someone has to do them for you, and that is usually a guardianship, and that's a court proceeding to get that established, and it's expensive. So just having a simple power of attorney, a durable power of attorney, and a medical power of attorney is one of the best ways to avoid having to deal with that aspect of it. And at some point, we're all going to get old, and we're all going to have health issues of some form. And so that's just a real foundational document that you need to protect yourself. Another thing is not making gifts to reduce your estate tax, or looking and talking to a tax professional to determine how you can protect your estate from taxes. I am not a tax professional. That is not anywhere near my area of expertise. So you always want to make sure that you talk with a tax professional to find that out, because the gift tax and what the level is increases all the time. I don't even know what it is at this point, but I know years ago it was about 17 or 18,000. It could be more now, and that's per year. And then there's a lifetime exemption, basically, for gifts. So these are the steps to really talk to a professional about, so you can make sure that you're protecting, because whatever, we need the government in some form or fashion, but there's no reason you need to pay more than the amount of taxes that you should, just because you didn't plan. Another big mistake is putting your child's name on your deed. So when you put your child's name on the deed, you're basically giving this huge tax gift to your child. If the gift is, let's say it's $21,000. I don't know what it is. Your house is probably worth much more than that, and so they will be taxed upon that. And so there are things that you can do, like I said, to avoid that. So doing a transfer and death deed, so you own the house, but after you pass, then it goes to your beneficiary. That is a much better way to handle that, and not put a loved one or a child name on your deed. Another big thing is putting the wrong person in charge of your estate. This is after you've left, but really, not just someone you've known all your life, but really, look for guides about what kind of characteristics a person really needs to have to handle a estate, because it's a lot of work, and they really need to be able to handle those, even if they're working alongside an attorney. It still is quite a bit of work, and they need to be able to do that properly. Another thing is not taking advantage of federal exemptions for your spouses. So if you're married, the easiest way is to pass your estate to your spouse to avoid some of those taxes. Again, talk to a tax professional about that to understand that more completely. Um, I think the most common thing that people do is they procrastinate. So even after some people contact me and they have started an estate plan, it can sometimes take months for them to fill out our um, intake. And I don't think it's because our intake's that complex. I think it's because these are hard decisions to make, and we understand that. But the longer you take, that's just putting off something that needs to get done. Unfortunately, I had someone call me years and years ago that was in stage 4 cancer. And he was like, I know I need to get this done. And we talked through it, and he didn't call me back, which is fine. But I know that he didn't do anything because sometimes people contact another attorney because his wife called months later. And she said that she was like, I know he talked to you. We haven't done anything. And I know we need to do it. And so I talked to her again through the whole thing. And this is someone that knows that they're going to pass in a relatively short period of time. And that can be very overwhelming and hard to grasp. We can make it so that it can be an easy process for you and an easy process for your loved ones while they're grieving. And so they're not having to wonder and worry about all these details that they've been taken care of. It's such a gift to your loved ones that you have that taken care of so that they don't have to worry about it. And lastly is that you do not meet with an experienced legal, financial, or tax professional to make sure that your assets and your estates are taken care of properly so that you, understand and make smart decisions about your estate plan. There are a lot of, ways to make sure that you have something set up. If you're a veteran, I know that there are organizations that have helped veterans do an estate plan or a will. There's a lot of different ways that you can get it done. Of course, our office at Cahoon Legal, we help many families with estate planning, and we would love to help you as well. But we understand that the important part is that you get one done, whether it's with us or not. Okay, now let's turn to just something more personal. We have lots of stuff going on with the kids starting back at school, and this is a little uncommon for us, but my daughter came to me and she's like, I want to go see a movie. And so we actually, I think it was in 1 week, we saw Twister, Deadpool, and then we watched Fall Guy. So I watched Deadpool and Twister at the movie theater, and I loved them both. I thought they were great. So Twister, if you have watched the first one, I would say that it is different. I would say that it's better. The original was fun and an interesting thing, and it was exciting. This newest one is fun and exciting, but it also had a much deeper human connection and a much deeper aspect to it that I thought was really good. And I thought it made the movie much just more impactful. I watched it with my daughters, and I was on the edge of my seat. It was really good. And then because I don't live in Oklahoma, but in Texas we do get tornadoes, and luckily in my many, many years of here, I've never actually been personally impacted by one, thankfully. But I have very close friends that are from Oklahoma. And so I talked with them and I was like, they've seen the movie. So I asked them how similar it was. So it was just really interesting to kind of hear their take on it. And because that was just such a way of life for them. And it's very different than what I've experienced, but it was a great movie. So I highly recommend it. Deadpool, if you love Marvel, if you love superheroes, it's very good. As you know, it's very raunchy. It is definitely earned its R rating. But I love seeing Wolverine. It's Deadpool and Wolverine. So it was great. It was really good. It had a lot of unique things about it. It had a lot of funny elements like it always does. And I will have to say that it was not, while it is raunchy and while it is, has stuff to it, I think some of the other ones, the earlier ones, were probably a lot more racy, if you will. So, anyways, it was a really good movie. And last we saw Fall Guy, which was really kind of a fun movie as well. I wouldn't say that it was great. It was a good movie. It was entertaining. And it was really kind of interesting because I did grow up watching the original TV show Fall Guy. So it was kind of fun seeing that, just nostalgia. But just realizing how much stunt guy or stunt double actually goes through, and different from the actual main actor. So that was interesting as well. So it was good. A lot of entertaining movies. I recommend all of them. But I think that Twister probably was my favorite because it was PG or PG-13 maybe. So, the whole family could go. Deadpool is definitely mature. And Fall Guy was appropriate for the family as well, but it just wasn't as high, maybe like a 3-star. And Twister was 5-star. Deadpool was 5-star. So that's all. That's all for Pro Bono. Thank you for listening, and I hope you learned more about legal topics that can help you in your daily life. Please share with your friends and family and send any questions that you have and that you want me to cover in any future episodes. Next month, we'll be discussing employment law. Have a great day.